Hello, this is Kathleen McNaught, and I am with the American Bar Association Center on Children and the Law, and I lead a project there known as the Legal Center for Foster Care and Education. And I am here today to present to you some information about the Every Student Succeeds Act, specifically focused on advancing school stability for children in foster care. Our Legal Center project is a collaboration of our center, the ABA Center on Children and the Law, and two other recognized national organizations, the Educational Law Center and the Juvenile Law Center. And together we are a national technical assistance resource and information clearinghouse on legal and policy issues affecting children's education when they are in foster care. I encourage you, as you see on the bottom of this slide, to, if you have not already familiarized yourself with our website, please go to our link, www.fostercareandeducation.org, and you'll find a whole host of resources, trainings, materials. We have an interactive database, various publications, archived webinars related to children in foster care and their educational issues. Our Legal Center focus is on improving well-being for children in care through a focus of attention on their educational stability and success. And so we work on a lot of different levels. We work at the federal level, working with folks on the Hill, as well as folks in the various agencies and administration and federal and national organizations. We work with individual states and local jurisdictions. And what we do with them is a variety of different activities, but for the most part, a large percentage of our work is facilitating multi-system conversations and collaboration. So working to really align the policies and practices that are taking place in state and local jurisdictions between schools, child welfare agencies, courts, legal advocacy groups, to ensure that everyone is working together in a coordinated way to meet the needs of children in foster care. As I mentioned before, we do create tools and resources, and certainly this recent passage of ESSA has been a big focus of the resources we have been developing to focus on specifically how ESSA addresses the needs of children in foster care. But we also create tools and resources on other issues, such as the Individuals with Disability Education Act and some of those specific provisions that impact children in foster care, Family Educational Rights Privacy Act. So again, I really encourage you to take a look at our website to see the broad array of resources that we provide related to educational needs for kids in care. Another big focus of our work, in addition to following federal and state law and policy changes, is also an emphasis on the importance of data sharing across agencies and across systems. It is increasingly clear to everyone working in this area that unless education agencies and foster care agencies can share information about share educational information with foster care and child welfare agencies about how to meet the educational needs of those youth, that we aren't going to be able to track and measure progress. We aren't going to be able to determine where there are gaps and how to identify resources to improve the strategies and services in place for those youth. So on this slide, you'll see a link at the bottom to a national fact sheet on foster care and education. And I really encourage you to take a look at the full publication. It's a 20-page document that has full citations of all of the different research, both state, regional, local studies that have revealed some data or outcome related to educational outcomes for kids in care. I can say two things about the data. We certainly wish there was more data to support or to document how children in care are doing. But from the data that we do have, it has been pretty well documented that children in care experiences much higher rates of school suspensions, have far lower standardized test scores in reading and math than their non-foster care peers, have high levels of grade retention, higher rates of dropout, and far less young people, although there is a high desire to complete high school and attend college, far lower rates of high school completion and ultimate college graduation and success. This slide gives you a bit of a snapshot picture of what we're talking about when we're talking about children in care who are school age. And obviously this is from a few years ago, but understanding that roughly 249,000 children in 2012 were in care and were of school age. It also gives you a picture of how frequent we see living placement instability occur for children when they enter care. Obviously the initial entry into care it will by definition be a placement change, but we also see children in care moving during their foster care episode, during that period of time in care. And so what that number says is the average number of living placements, living changes during a foster care episode was 2.8 moves. We also see other sort of snapshot pictures, higher likelihood of being absent from school than their non-foster peers. 56 to 75% of foster youth who change schools when first entering care. So we see high rates of school changes that coincide with that initial living placement change. We also see 34% of 17 to 18-year-olds in care who've experienced 5 or more school changes. So that's a pretty high number of kids who have changed schools a lot. An average reading level of 17 to 18-year-olds in foster care is on average being at the 7th grade level, and the likelihood of youth receiving special education 2.5 to 3.5 times higher than their non-foster peers. And I think that's really significant for this audience to really think about when we look at children in care and that far higher rate of incidence of receiving special ed services in schools. The research has indicated that children in care have a far higher rate of emotional and behavioral problems impacting their education. So we see a lot of those youth identified with sort of the emotional impairment designation within special education. But we also see a lot of children with learning disabilities and other disability categories within IDEA. The research also suggests that children in foster care who are in special ed tend to change schools more frequently, be placed in more restrictive educational settings, and have poorer quality education plans than their non-foster care peers in special ed. And I think that really helps, that piece of research really helps tie together what we're here to talk about today, which is how ESSA, in coordination with the Fostering Connections Act, which deals a lot with educational stability, ties into kids with disabilities, and how do we merge all of these laws and policies in a way that's really going to benefit kids. So I know I'm here to talk about the Every Student Succeeds Act, but I think it's really challenging to do that until we do a little bit of a background groundwork laying to describe very briefly the Fostering Connections to Success and Increasing Adoptions Act, which is a law that passed back in 2008. It amended provisions within Title IV-E and Title IV-B of the Social Security Act. So that is where we find federal child welfare law provisions. And it amended a variety of different things in federal child welfare law, issues involving guardianship and kinship care, tribal issues, health issues, particular provisions impacting older youth. But what was very significant back in 2008 is for the first time child welfare law had some significant language and provisions that were addressing education for kids in foster care. And so what were those? The most significant provisions within Fostering Connections were these changes that require the inclusion within a child's case plan of an educational stability plan to be part of every child's case plan. And in that stability plan, there had to be assurances that each placement would take into account the appropriateness of the current educational setting and the proximity to that school in which the child is enrolled at the time of placement. So this is an assurance that child welfare agencies will think about where kids are attending school prior to identifying or while they're identifying an appropriate placement for that child, that they'll consider how to maintain school stability as part of identifying the appropriate living placement. And they also will be are required to think about the proximity and how well that current educational setting is meeting that child's needs. So how appropriate is the current school to address the needs of that child? Child welfare agencies also, through that educational stability plan, have to coordinate with local education agencies to ensure that youth remain enrolled in their school in which the child was enrolled at the time of placement. And so this was brand new in 2008 in federal child welfare law, and it was the concept that kids remain in their same schools, that we should maintain school stability even when living placement changes occur. If it's not best for the child to remain in their original school, child welfare agencies had to ensure immediate and appropriate enrollment in a new school and also ensure that their educational records of the child would be provided to that new school. So again, just a little bit of a flashback to what the state of child welfare law from 2008. And now we're going to do a flash forward to just several months ago when the Every Student Succeeds Act passed in December of 2015. As most of you are probably well familiar, it reauthorized the Elementary Secondary Education Act, which is the leading federal education law. And the last time it was reauthorized was in 2002 under what was known as the No Child Left Behind Act. And I think what is very significant for those of us focused on the unique needs of children in the foster care system, that the Every Student Succeeds Act is truly the first time that federal education law has provided meaningful provisions related to how to protect children in foster care and ensure their stability and success. And so I think what we're going to do for the next several slides is really delve into the content of what those ESSA foster care provisions are. I think three big things to keep in mind as we do that walkthrough is first, know that this law, the ESSA foster care provisions, paired with those 2008 school stability provisions in Fostering Connections, truly envision dual agency responsibility. They're almost two halves of a circle, and so we need both of these laws to be implemented together and in an integrated fashion to really meet the needs of kids. There are some short timelines in this ESSA foster care provisions. Some of the shortest timelines in the whole Act are the ones that impact children in foster care. And so as early as December of this year, 2016, certain things have to be in place. We're going to talk about that in a minute. But from your perspective, what I think I need folks to know is that advocacy is needed, and there is a sense of urgency to make sure that these ESSA provisions are implemented in the right way. This law is obviously a very important step. But it is going to be the state and local action that turns these provisions into the true supports that kids need. And so it's the state and local implementation that we're really focused on right now to make sure that kids really see the benefit that was intended in passing this law. So the areas I'm going to touch on are school stability protections, transportation, which obviously has a strong overlap with those school stability protections. There's also some interesting new provisions related to points of contact, which or some people call designees, liaisons. It's those people resources within schools as well as within child welfare agencies that can really help break down barriers and support youth. And then finally, the removal of awaiting foster care placement, a category of eligibility within McKinney-Vento that goes along with some of these protections. So let's talk about school stability first. So you just heard me talk a bit about what the Fostering Connections Act said about kids remaining in their school of origin unless it's not if it's determined that it's not in their best interest immediately enrolling in a new school. And that stability needed to be in collaboration with their education agency partners. Well, what we'll find the language in ESSA around school stability to really mirror that type of language that we found in Fostering Connections. For ESSA, we see that it's built into the state Title I plan requirements, that descriptions have to be clear from the state agency about how they will ensure collaboration with their state child welfare agency partners to ensure the educational stability of children in care. And so it really is the reciprocal obligations that were found in Fostering Connections that now require both agencies to work with each other. The state plan must include assurance that youth in foster care are enrolled or remain in their school of origin unless a determination is made that it's not in the best interest. So again, very similar to the language we saw in Fostering Connections. ESSA does go on and talk about the best interest determination has to be based on specific factors, and those factors are similar to things that Fostering Connections required child welfare agencies to look at as well. The appropriateness of the current educational setting, the proximity to the school in which the child is enrolled at the time of placement. Just today, and since folks will be listening to this for some time I think, I will say that today is June 23rd of 2016. Some brand new guidance was just released from the U.S. Department of Education and the Department of Health and Human Services, joint federal guidance that I've included a slide at the end of this presentation to see the full text of some of that information. But this is very new information, and within that guidance, there's a whole host of factors that states can consider including to consider when you're making these best interest decisions across agencies. So what are some of those things we have to think about when determining if it's not best for a child to remain? Things like distance from the home to the school, how long has a child been attending that school, what is a child's permanency plan, meaning is there a likelihood of the child returning home within a certain period of time? Will they be, is adoption the plan? Is reunification the plan? And so there's a whole host of different factors that states should be looking at when making those best interest determinations. The one thing that information has been, that has come out from all agencies has been quite clear is the cost of transportation to maintain a child in their same school is not a factor to consider when you're making a best interest decision. It obviously is something that has to be dealt with and figured out, but that's not a factor in saying what's best for the child. It's an issue that agencies have to work on once it's determined it's best for the child to stay. Who makes this school stability decision is another question that comes up a lot, and I think between this most recent guidance, both Fostering Connections and ESSA, it's become clear that we want these decisions to be made with all of the right people who have all of the relevant information related to that child together, and to make sure that we're making the best decision possible. But that if it comes to a point where all parties can't agree, that ultimately child welfare agencies have the ultimate responsibility to make the final call. Particularly for this audience, I think it is clear that there are so many people that the agencies need to consult with in order to make that decision. And for students who have disabilities in schools, that includes key school staff, whoever is making educational decisions under IDEA. So what we're calling here the IDEA parent, which could be the child's parent, but it might be someone else, and we're going to talk about that a little later in the presentation. Folks from the IEP team, key IEP team members, might be really critical in finding out information. Not just for the IEP team's decision, but here we're talking about the school stability decision, which is separate from the IEP decision, but certainly there are links and correlations that have to be made. So now that we've talked about best interest decisions and when a decision is made that a child would remain in their original school, the next step is to think about how are we going to address transportation. And let's first talk about exactly what ESSA says related to transportation provisions. And here's where we're going to see the very first early timeline issue under ESSA. By December 10th of 2016, local Title I plans must contain an assurance that the local education agency has collaborated with Child Welfare Agency to develop and implement clear written procedures for how transportation to maintain youth in foster care to their school of origin, when in their best interest, will be provided, arranged, and funded for the duration of time and care. So what this means is ESSA is requiring, through the leadership of your local Title I directors, to ensure that you're collaborating with child welfare to be clear on how this transportation is going to be addressed. Provided, arranged, and funded. I think that really covers the gamut. The other thing that we find in the new law related to transportation are some of these requirements. The LEAs must ensure that youth in foster care who need transportation to the school of origin promptly receive it in a cost-effective manner and in accordance with the Child Welfare Agency's authority to use Child Welfare 4E funding. It also goes on to say that LEAs must ensure that if additional transportation costs are incurred, LEAs will provide transportation if the LEA agrees to reimburse the Child Welfare Agency, the LEA agrees to pay, or the LEA and the Child Welfare Agency agree to share costs. So what does all of this mean at the end of the day? I think ultimately these laws say that we have to ensure that kids, when they need transportation, are going to receive it. There's a reference to cost effective, and I think that puts a collaborative burden on both schools and child welfare agencies to think about how to arrange these transportation costs in the most efficient and economical way possible. There also is cross-reference to the 4E funding option. It's important to know that there is some allowable use of Title I 4E dollars, which is a federal child welfare funding stream that goes to states and localities to support school of origin transportation. It would apply for some kids, and it would be a partial reimbursement of those costs. So it is not a full solution to the transportation cost question, but it is a piece of the puzzle that ESSA is encouraging be accessed and be considered in developing of these transportation plans. I think the other important piece is remembering this concept of additional transportation costs and making clear that ESSA does not mean that whenever a child in foster care is granted a seat on an existing bus, that that's an additional cost. That it would be a normal cost that student would that's a normal cost that student would have if they were attending their home school. We have to remember that additional transportation costs really mean any costs in addition to maintain that child in their school of origin when they aren't living in that school's jurisdiction. I think the one last thing I want to say about transportation, as it particularly relates to kids with disabilities and kids who are eligible under IDEA, is again to remember we have a lot of overlapping requirements that we're trying to navigate in serving kids. So we've got the Every Student Succeeds Act, provisions related to foster youth. We have the Fostering Connection School Stability provisions and how those laws overlap. And then when you have a child in foster care who also has a disability and is eligible under IDEA, you also have IDEA requirements that sort of are superimposed as well on top of that. And I think it's really critical to know that if a child is entitled to transportation, transportation is written into their IEP as part of the services that they're entitled to under IDEA, then they're entitled to those transportation costs under IDEA. And these issues don't come into play. If they're not entitled to transportation under IDEA, if they're a child in care, they still could be entitled to the transportation through ESSA. So I hope I made that clear. But I think that the key here is to know how to navigate these different laws, especially when they overlap. So finally, we've talked about school stability. We've talked about maintaining children in their school of origin. We talked about transportation. In a minute, we're going to talk about immediate enrollment requirements. And what ESSA has done related to a phrase, awaiting foster care placement, that's part of the McKinney-Vento Act, is that it's made the determination that in almost all states, 1 year from enactment, again, which will be December 10th, 2016, that phrase, awaiting foster care placement, as an eligibility category within the definition of a homeless child and youth under McKinney-Vento will be eliminated from the law. There's a handful of states where their awaiting foster care placement definition was established in their state law or regulations, and those states are being granted an additional year to phase out awaiting foster care placement. And the real intent here is to say, for many jurisdictions, only some children were determined eligible through awaiting foster care placement to be eligible for McKinney-Vento. And what this law and these new provisions do is that they apply to all kids in foster care. And therefore, the eligibility through McKinney-Vento is no longer necessary, because all children in foster care in these jurisdictions will be entitled to the school stability protections, similar, not identical, but similar to the ones you see in McKinney-Vento. So earlier we discussed when a best interest determination, when a child, it's determined that it is best for a child to remain in their school of origin. When it is not in the child's best interest to remain in that original school, ESSA, similar to Fostering Connections, makes clear that the child will be immediately enrolled in a new school. That is identical to what Fostering Connections said as well. What ESSA goes on to say, which I think is very important, is it makes clear that that immediate enrollment can be even without the normally required records that a school might determine are necessary to complete enrollment. And that is very similar to the McKinney-Vento Act provisions for kids who meet the definition of homeless, in that failure to be able to produce particular records cannot be a reason to not immediately enroll a child who is homeless, as well as now a child who's in foster care. Obviously, best practice tells us that we should be working quickly to obtain copies of those documents, particularly if they're key documents that will help to plan or meet the educational needs of that student. But they can't be a reason to delay enrollment. ESSA also is specific and places the enrolling school with the burden of making contact with that previous school to obtain those academic and other records. So it's sort of that school-to-school record transfer that's being required through ESSA. I'm jumping outside of ESSA for a minute, because as I was looking and preparing for this presentation, it really occurred to me that we're talking about record transfer, when we're talking about immediate enrollment. This is another one of those key places where it's very hard to think about applying ESSA to kids with disabilities who are eligible under IDEA without a very quick reminder that IDEA also has some very specific provisions that talk to when kids with disabilities are transitioning in school. So when a child has an IEP and changes school districts, moves to a new school district, I just put this slide here to remind everyone that there are specific requirements under IDEA about how that new school needs to provide comparable services to the IEP that's being from the old school up and until the new school develops a new IEP. So they either can adopt the old IEP and provide comparable services, or develop a new IEP. And the same is true when it's within state or out of state, although from another state there's the possibility of an additional evaluation piece. Another transition piece that I think is a common one we hear, and has that added layer when it's a child in foster care, is what happens if the child is in the middle of an evaluation when the school move occurs. And I also think it's important to remember, again, this isn't coming from ESSA, this is coming from IDEA, that there are specific rules about how that initial evaluation time clock needs to continue, even if the child has moved school districts. So typically, I think probably most people know you have 60 calendar days to complete that evaluation process. And if a child moves before that evaluation period is complete, the only way the time period can be extended is if the school is actually making sufficient progress and the IDA parent and the school district agree to a new timeline. And so otherwise, the existing timeline needs to be met. The other area, not necessarily specific to evaluation or the IEP itself, is just how are we making sure that the records are transferring in an appropriate way. And it was just interesting to think this through. And Fostering Connections said the child must be immediately enrolled with all the school records following. ESSA has some, again, similar, immediately enrolled, even if there are missing records in the child's educational packet, even if you don't have all those typical records required for enrollment. And then the enrolling school must contact the previous school to obtain those records. Remember, too, that IDEA spells out that the new school district must take reasonable steps to promptly obtain the child's records, including those special education records. And the previous district must take reasonable steps to promptly respond to this request. So when we're talking about a child in foster care who's also in special education, I think all three of these provisions have to be read all together to know that there's a lot of different angles on the protections for this group of kids. But the short of it is that the records should be following and should be following timely. Okay, so I'm going to jump back to and round out some of the last pieces of the new ESSA requirements related to kids in foster care. And these next two areas relate to those people resources, or the points of contact as the law calls them. So the first key point of contact that the new federal law requires is that every state education agency must designate someone to work with child welfare agencies to oversee implementation of the new responsibilities for students in foster care. So we're going to see now in every state a foster care point of contact in that state education agency. For those of you familiar with homeless education, through the McKinney-Vento Act, there already exists a state coordinator for that for McKinney-Vento. And so there's a homeless student coordinator, point of contact in every SEA. And the only requirement that the federal law has placed on who this person could be is it can't be the same person who's designated for homeless kids and for McKinney-Vento. And I think that really is designed to address some of the concerns about making sure that each one of these individuals within that state agency has the time and capacity to serve the needs of those homeless youth and the foster youth that they're designed to serve. The next point of contact that the law is now requiring is at the local school level. So for each individual school district, could be a charter school, any entity within your state that's considered an LEA, they must designate a point of contact for children in foster care as well. But it's only if the child welfare agency, the companion child welfare agency that works with that school district or school, notifies that LEA that it has designated a point of contact within the child welfare agency for the LEA. So what does that really mean? Any school district can choose to identify a point of contact. And given all that we're talking about here and these new requirements to meeting the needs of children in foster care, it really is a best practice for every school district to have someone who understands these unique issues related to kids in care. But they have to designate that point of contact when they've been notified by their child welfare counterparts that they have one in place. They have an education point of contact within the child welfare agency. So it's a triggering event to ensure that there really are the people resources on in both agencies to coordinate with each other, again, break down barriers, and meet the needs of kids. So I wanted to add a few slides here at the end for an issue that I think overlays everything that we've just talked about, whether it's about fostering connections or ESSA, and that is this issue of who ultimately makes decisions for kids when they're in foster care. And for those of you who have worked in the special ed arena and are more familiar with IDEA, I think it's really important just to add this as a reminder that for kids in care, who makes IDEA decisions can often be an area of confusion. And I've tried to in this slide pretty much summarize sort of the big picture thoughts on that, which is first, it could still be the parent. Even if the child is no longer living with that parent, unless there has been some kind of limitation of that parent's right to make education decisions, or unless there's something in your state law that limits that parent's right at removal, that parent would continue to make education decisions. IDEA also defines a parent to include several different individuals, including a foster parent or a caretaker who the child is living with. So there are there is a possibility that there will be a multiple number of individuals who would meet the definition of an IDEA parent. So the other piece that's important to know is the birth or adoptive parent will typically trump any of those other people if they are present and what the law says is attempting to act as the person making decisions. But the law also says that the courts can intervene, and a court can trump all. So if a court says, no, it's not going to be the birth or adoptive parent making decisions, they can identify somebody else to make those decisions. The last thing to note is in addition to a definition of parent under IDEA, we also have a process for the appointment of a surrogate parent, which is something very unique for kids with disabilities under IDEA. Those appointments can be made by a school, and those appointments can also be made by the court. I think it's really challenging not knowing who you are right now listening to this presentation to be able to give you more concrete information about IDEA decision making, but I did want to provide you, I think, with this key list of questions, which are the ways that your state law and practices could vary. So some of the things you really need to know is whether or not a foster parent is permitted to serve as the IDEA parent in your state, how your state defines or whether your state defines a ward of the state. That's going to impact how surrogates are appointed. When are surrogates determined to be needed in your state? That can also vary. And whether or not your judges appoint people to be the IDEA parent in addition to their clear authority to appoint individuals as surrogates. I've included a link at the bottom of the slide to information, to a whole issue brief we've written on this topic that I think could help expand on some of those questions and explain these issues even further. So I encourage you to take a look at that if IDEA decision making is an issue in your jurisdiction. Finally, as I mentioned earlier and a couple times throughout this presentation, this morning some brand new joint federal guidance was released by the U.S. Department of Ed and as well as Health and Human Services to assist states and local jurisdictions with implementation of these foster care provisions in ESSA. I really think it's a tremendous statement that these federal entities were able to come together and draft and issue a pretty extensive joint guidance on this topic, and I think it's going to really serve as a model to the joint agency collaboration that is going to need to happen at the state and local levels to ensure success. I will point out that there are several places within that joint guidance where they specifically speak to kids with disabilities and how IDEA interplays with ESSA, so I really encourage you to take a look at that new guidance. And I also provided to you a handful of resources, some of them bringing you back to, as I said, our fostercareandeducation.org website, where we've got a lot of information and certainly more to come on ESSA and how it applies to kids in foster care. I also, we have information about special education and decision making, a whole series of articles and Q&As that I encourage you to take a look at, as well as some other resources that I think are relevant to all of what we've talked about. So my name again is Kathleen McNaught. I'm happy to take any questions or at this email address. If you are watching this presentation and want to learn more, have questions about any of the information I presented, I'm happy to support you. And I just want to thank you for the work that you do to support kids with disabilities, and particularly for those who are involved in the foster care system. Thanks so much.